All right, I see indicators on my Zoom screen that we are recording and we are streaming. So unless I hear differently from IT or Mr. Myers, I'm going to go ahead and begin. Good morning, everyone. We are now on the record and video streaming in this proceeding, and I'm calling the evidentiary hearing to order. These are the consolidated dockets 20 CONS 3129 CPEN, 20 CONS 3144 CPEN, 20 CONS 3220 CPEN, and 21 CONS 3199 CPEN, captioned in the matter of resolving K.A.R. 823111 issues associated with Prairie Gas Operating LLC in 4 consolidated dockets regarding wells in Greeley and Hamilton counties, Kansas. I am Chairperson Andrew French of the Kansas Corporation Commission, and I'll serve as the presiding officer for this hearing. And I'm joined by my fellow commissioners, Dwight Keene and Susan Duffy, this morning. We are going to begin this morning with the entries of appearance by the 2 parties, and I will start with commission staff.
Good morning, Chair French. Kelsey Marsh on behalf of the commission staff and the public generally.
Good morning, Mr. Marsh. Thank you. And for the operator, Prairie Gas.
Yes, good morning, Commissioner Lee Thompson on behalf of Prairie Gas Operating, and Mr. Ian Acree is also present, who is the president of Prairie Gas.
Very good. Good morning, Mr. Thompson. We will now move to notice. Does staff have a recommendation regarding notice of this hearing?
Yes, notice of this hearing was contained in the presiding officer's November 2nd order setting an evidentiary hearing in these consolidated dockets for Thursday, December 16th, 2021 at 10:30 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. Further, staff notes that operator and its counsel are in attendance today. Based on these facts, staff recommends the commission find notice is proper and that the commission has jurisdiction to hear this matter at this time and place.
Thank you, Mr. Marsh. Any objections to notice?
No objections.
Thank you. Hearing no objections and based on staff's recommendation, I will find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. We will now move on to preliminary matters. And first, I'll have just a few of my own to discuss the procedure for the hearing over Zoom. Some folks have done our Zoom hearings and some haven't. So let me run through just a few ground rules. First, because we're conducting this over Zoom, sometimes things can go wrong. If any party encounters any technical issues, please just unmute yourself, ask us to go off the record. We can resolve the technical issue and then we will go back on the record. Second, we do ask that witnesses keep their microphones off or muted when they're not scheduled to talk. And if everybody would please also mute their cell phones, phones in their offices, other electronic devices, that would be very much appreciated. Third, so that the parties are aware, if the commission needs to consult among ourselves, we'll go off the record and the commission will enter what's called a Zoom breakout room to discuss whatever we need to discuss. And then we will return from that breakout room and go back on the record. Fourth, since we're doing this by Zoom, please be especially careful to identify exactly what you're referring to when discussing either pre-filed testimony and filings or exhibits. We do have copies of all of that on hand, I believe, so we should be able to follow along if those who are referring to items specifically identify them. Now, do the parties have any other preliminary matters to take up at this time? Hearing none, we will move to the procedure for the hearing. In regard to the procedure for the hearing, the parties are typically allowed to make opening statements. Following those opening statements, we will have the examination of the witnesses. There will be direct examination of the witness. Then there will be an opportunity for cross-examination by the other party, followed by questions from the commissioners. And then we will allow redirect within the scope of the cross-examination and commissioner questions. Any further examination would be purely at the discretion of the commission. Following witness examination, parties typically make closing statements and arrange for the filing of post-hearing briefs if necessary. And then we will conclude the hearing. So at this time, I believe we are ready for any opening statements the parties wish to make. And I will begin with Mr. Marsh, if you wish to make an opening statement.
Thank you, Chair French. May it please the commission. We are before you today to determine two issues. First, whether Prairie Gas Operating LLC should be required to conduct casing integrity tests at its Earl 1, Fecht D1, and Watson No. 1 wells based upon the high and dramatically changing wellbore fluid levels at these wells. Second, we are here based on Prairie Gas Operating LLC's appeal of the penalty order issued by the commission in docket 21-CONS-3199-CPEN. The commission found the operator in violation of K.A.R. 82-3-111 at 27 wells because the operator failed to respond to notice of violation letters sent regarding each well. The commission also issued a $20,000 penalty as part of its order. The operator has come into compliance regarding some of these wells. However, the operator failed to take any action until after the commission issued its penalty order in the 21-3199 docket. Commission staff believes the testimony on file and the testimony provided today will show that operator needs to conduct casing integrity tests at its wells and that the 21-3199 docket should be affirmed. Thank you.
Thank you, Mr. Marsh. Mr. Thompson, would you like to make an opening statement on behalf of the operator?
I would, and I may be just a little longer, but I'll be sensitive to the time issue. Excuse me. I am Lee Thompson of Wichita, and I represent Prairie Gas Operating, and I appreciate the opportunity to have this hearing. I am aware that the testimony on direct has already been presented, and we will certainly endeavor to be precise in our presentations in light of that. However, there are, of course, multiple consolidated dockets. And quite frankly, I think there are quite a few moving parts because of the interrelation between this matter and some prior matters dealing with Prairie Gas. So we will have the majority of our evidence, of course, will relate to 21-3199, which involves 27 wells and the penalty order issued in connection therewith. But I think if we provide some context, it would be important because, quite frankly, the issue of what would normally be a routine matter of violations of K.A.R. 82-3-311 is in substantial measure complicated, at least as to 6 wells and the 3 wells previously, because of what we believe is kind of unfettered exercise of authority by the staff without appropriate issuance of precise penalty orders. So first, let me just talk briefly about the 2 prior dockets, 3129 and 3220. Those, of course, originated with violations in June of 2020 and January of 2021. All of the notices of violations stated that they were probable violations of K.A.R. 82-3-111. And certainly Mr. Meyer's testimony already shows there's no doubt that staff believes that they have authority to order a well to be plugged if they perceive some sort of threat to usable water. However, in this matter, the testimony so far is far more elliptical and speculative. Mr. Jellick testifies he has concerns about potential pollution of usable water in the 3 wells at issue and the license suspension and the 6 wells at issue in 3129. I believe the testimony will disclose that these opinions are based on untimely measurements, lack of specificity as to the water table, and no specific studies or analysis about the need to conduct expensive and invasive tests on the wells, which in no small part has been producing and dewatering. As late as March 11th, 2021, there had been no penalty order issued on the 27 wells, we believe the evidence will show that the notices of violation were issued substantially before that. But on March 11th, 2021, Prairie Gas filed a motion to lift a license suspension. And it is while that motion was pending that the penalty order in 21-31-29 was filed. And again, it relates to authority of the staff, which they cite under 82-3-111C, although that was not cited in the original penalty order as a basis for the opinion. The Commission on April 20th issued its order lifting the suspensions of the license, holding in part that if Prairie had in fact resumed production, and I assume the Commission is familiar with its own orders, so I apologize if I'm getting too far afield, but it ordered that including dewatering, the Prairie Gas was in compliance with the order's specified requirements. One reason I think post-hearing briefs will be helpful because the evidence should support an argument that the continuing attempt by the staff to exercise kind of unilateral rights to impose costly and counterproductive tests in the absence of specific findings and conclusions of the Commission in a normal penalty order is important. We recognize that the prior orders exist, but we think that this hearing will justify a request for further clarification and specificity as to the staff's authority to mandate its actions without findings and conclusions. As it relates to the 21 wells at issue in this case, it will be shown, I believe, that a number of the penalty notices were issued during the pendency of the license suspension. Thus, it was, of course, very problematic whether or not Prairie should do anything during that time. And I think that's an important factor that we will bring out. Obviously, Prairie did not comply with all of the notices of violations, but much of that was due to the license being suspended. Once the license was reinstated, Prairie began the process of complying, noting issues, of course, with weather and finances. We believe that the evidence will show that at least 13 of the 21 wells were in fact granted TA status signed by Mr. Meyer after the license suspension was lifted. I take the staff's position to be that that's irrelevant because they weren't in compliance previously, but because they were the action was taken after the license suspension was lifted, I think it shows a considerable degree of good faith. And if nothing else, I think since a penalty is a component of this proceeding, that is an appropriate consideration for the Commission to look at if in fact it deems that a penalty is necessary. So I would request that we keep in mind the overall context. Some of my cross-examination will go into that, but again, I know that these matters are pretty well in front of the Commission, so I will do my utmost to be as brief and appropriate as possible. Thank you very much.
Thank you, Mr. Thompson. Let's see, I believe we can now proceed to the examination of witnesses. And I have staff's witnesses listed first. So Mr. Marsh, you may call your first witness.
Thank you, Chair French. Staff would call staff witness Michael Meyer.
Yes.
And good morning, Mr. Meyer. We do not have a court reporter this morning. We're recording and we'll be transcribing later, but because we don't have a court reporter, I will be swearing in the witnesses. So at this time, can you please raise your right hand and answer my question? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Marsh, you may proceed.
Thank you. Mr. Meyer, can you please state your full name for the record?
Michael J. Meyer.
Mr. Meyer, by whom and in what capacity are you employed?
I'm employed by the Kansas Conservation Commission, District 1 office.
And Mr. Meyer, what is your work address?
My work address is 210 East Front View, Dodge City, Kansas, 67801.
Are you the same Michael Meyer who caused to be filed in this docket direct testimony consisting of 10 pages and 2 exhibits, and rebuttal testimony consisting of 4 pages and 2 exhibits?
Yes, sir.
Was this testimony created by you or at your direction?
Yes, sir.
Now that you are under oath, do you have any corrections or additions to make to your testimony?
No, sir.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes, sir.
Do you swear the answers contained in your pre-file testimony were and are true to the best of your knowledge?
Yes, sir.
At this time, I would move for the admission of Mr. Michael Meyer's direct and rebuttal pre-filed testimonies into the formal record.
No objection.
The reference testimony will be admitted into the record.
At this time, we would tender the witness for cross-examination.
Thank you, Mr. Thompson. The witness is yours.
Mr. Meyer, are you, I assume, familiar with the penalty order issued in the 27 well docket?
Yes, sir.
Do you have that in front of you or available to you? If not, I've submitted a copy as Exhibit 110, which we could screen share for you.
Let's go ahead and do that, John, for the benefit of everyone on here. If you have it, Mr. Myers.
I've got it.
I also have it. I can screen share it. Hold on.
That'd be great. Folks who have it in paper can follow along there, but we'll go ahead and put it up on the screen for anybody that doesn't have it in paper.
Okay, thank you. This penalty order was issued on April 13th, 2021, correct?
Yes, sir.
And it's issued pursuant to notices of violations, which I believe in your testimony on page 4, you say date from June 16th, 2020 through January 22nd, 2021. Do you agree with that?
Look at it. Yes, sir.
Okay. And the notices of violation all specified they resulted from probable violations of K.A.R. 82-3-111, correct?
Yes, sir.
None of them specified a discrete violation of K.A.R. 82-3-111C, did they?
No, sir.
Okay. And likewise, none of them recited that they resulted from a probable violation of K.A.R. 82-3-104. Is that correct?
Yes, sir.
I believe that your testimony suggests that 6 of the notices of violations had the words high fluid level on the notices, but also there was no regulation listed relating specifically to high fluid levels in the notices of violation, were there?
That's what 82-3-11 involves also.
And it involves in 82-3-111, was it cited in the notice of violations as applying to high fluid levels?
When the notice was sent out, it was stated that it was a high fluid level. What each one is denied for, there is a letter that's sent out stating why it was denied. Yes.
But in the notice of violation, it just said high fluid level, correct?
Yes.
And I would ask that we look at Exhibit 111, Mr. Meyer, and if Mr. Myers would bring that up, I'd appreciate it.
One moment.
Mr. Thompson, can you just identify for us what Exhibit 111 is, what document that is? So if Mr. Meyer is looking through his papers, he could find it.
Yes, I apologize. I would submit for identification Exhibit 111, which is a collection of the notices of violation submitted in Exhibit A of his testimony in 27 pages. And I'm just going to show one or two to him for an example.
Commissioners, can you see the Meyer Cross Exhibit 111?
Yes.
All right.
Have you had a chance to look at that, Mr. Meyer?
Yes, sir.
And I'm just going to look at the first one, which involves the Floyd A1. Would you agree with me that every one of these are notices of denial of TA? I think I may have misstated that they were the notice of violations, but do you understand that?
Some of them were because they didn't file their TA and the others were because of high fluid level. Yes, I understand that.
Okay, I just wanted to make sure that I correctly identified what the exhibit was, which is not the notices of violation, but rather they were the letters denying the TA application. Do you agree with that?
Yes,
And these all contain exactly the same wording, do they not?
yes, yeah, they do.
And they state that pursuant to K.A.R. 82-3-111, the well must be plugged or returned to service or obtain temporary abandonment status by a date certain, correct?
Yes,
It does not reference anything specific about the process or procedure or violation related to a high fluid level, does it?
it just states that it's a high fluid level.
Yes, thank you. Were you aware that the license of Prairie Gas was suspended on in docket 3220 on September 24th, 2020?
I don't remember the exact date it was suspended, no. But if it states it, yes, that's when it was.
Okay. Perhaps we can look at exhibit 112 just to make sure we're all on the same page, and I would identify that as two letters being notices of license suspension, and ask if you take a look at that and indicate whether you were familiar with it.
John Myers here. Mr. Marsh, you were also being emailed these simultaneously.
Yes, sir.
The notice of license suspension would indicate that it states, does it not, that until it was reinstated, it is illegal for you to conduct oil and gas operations in Kansas?
They can't conduct oil and gas operations, but we can still act on these suspension or act on each one of these through Kohler. If they file a TA, they can file a TA and I can approve and disapprove even if their license is suspended.
Okay, but in terms of going in, working on the well, would you not agree that there's a good question raised as to whether or not what they can do to the well during the period of time that their license is suspended?
That's why they should contact us and we can talk about it. And they didn't, so there's nothing we can do about that.
And are you saying you had no contact with Prairie Gas during the time that their license was suspended?
I didn't personally. I had one phone call that I remember. See. I only had one phone call that I remember while the license was suspended, and they asked what they needed to do, and I said, get a witness fluid level test done.
And that was your belief as to what they needed to do, correct?
Well, for the ones that didn't have a fluid level, or why they weren't filing because they didn't have a fluid level, yes, for that. Now the high fluid levels were a different story, and that's what we needed to talk to them about, yes.
Okay. But the operator filed a petition to lift the suspension of its license on March 11th or 12th in 2021. Were you aware of that filing?
Objection, relevance.
We'll let him proceed.
Were you aware of the filing of the petition to lift the license suspension?
I didn't know the exact date. I knew that they had filed to lift their suspension, yes.
And the penalty order at issue in Docket 3129 was not entered until after Prairie Gas had filed its motion to lift the license suspension, was it?
Objection, outside the scope of his testimony.
This is cross. I think it goes to the theory of our case.
Mr. Thompson, if you could just briefly explain how this relates to the two issues that we've defined for the hearing. I'm inclined to give some leeway, but if you could just give an explanation of how it relates.
I think it relates on the 27 well docket to whether or not Prairie Gas in fact was able to operate during the time that the license was suspended, given the wording of the license suspension orders. And it also goes to raise a question as to what motivated the filing of an extensive penalty order of 27 wells long after they had issued notices of violation in the past. And quite frankly, we think that's relevant to the need to have more clarity on the identification of the precise penalties at issue for high fluid, for the presence of fluid.
I think I'm still struggling a bit with how it relates to, specifically the issue of whether there should be a casing integrity test or not, or I guess the second issue of whether 111 violations occurred. But I am inclined to go ahead and let you proceed and try to tie those in. But I will ask you to be very careful to try to tie it to those specific issues.
Okay. I think I've already asked the main questions that I think establish certain predicate facts that we would rely on to argue on some legal issues, and I appreciate the leeway being given. Mr. Meyer, I want to next direct your attention to the Prairie Gas applications for TA status on the 27 wells that issue in docket 213129 or 3199. Have you had an opportunity to review Exhibit A to Mr. Acree's testimony.
No, sir.
Okay. I'll get back to that and come at this a different way. In your testimony, you can see, I think, that 8 of the 27 wells were approved for TA status after the penalty order was issued. Is that correct?
Yes, sir.
And I believe those wells are listed on page 9 of your testimony. Is that correct?
Yes, sir.
Okay. So since the approval was given in April of 2021, may I assume that you do not contend that those wells are out of compliance currently?
No, currently they're not out of compliance.
So your position is that a penalty order ought to be issued because they weren't brought into compliance previously, including the period in which their license was suspended. Is that correct?
Yes, sir.
I would like to ask you about some other wells at issue in this that I'm a little confused by, relating to approvals of temporary abandonment. If we could show the witness exhibit 114.
One moment.
And that is copies of approvals of temporary abandonment of 5 wells, which to identify the exhibit. Have you had a chance to look at that?
The front page, yes.
Well, let me go through them page by page as quickly as I can. This is exhibit 114, a letter dated September 30th, 2021 regarding the Clift B 3-34. Is that correct?
Yes, sir.
And does it not state that TA application was approved for that particular well with your name at the bottom?
Yes, sir.
Would it then be appropriate to add that well to your list of wells which have been brought into compliance at least since the penalty order was issued?
Yes, sir.
Okay. Turning to the next page, this deals with the Herman A1, and it's a letter dated May 11th, 2021 with your name granting an application for temporary abandonment, correct?
Yes, sir.
And would you agree that that also ought to be listed, added to your list of wells that were in compliance after the penalty order was issued?
Yes, sir.
And I'd ask you the same thing about the Cutler B1, which is on the next page, a letter dated April 2021, indicating that the application had been approved.
Yes.
And would your answer to my questions be the same, that that ought to be added to your list?
Yes, sir. As long as I approved them. And
All right.
that's what it says.
All right. And on the next page is Sandifer A1. appears to be approved by you. Is that correct?
Yes, sir.
And that should be added to your list, correct?
Yes, sir.
And the cell A23 also ought to be added to your list. Is that correct?
Yes, sir.
As I understand your testimony, you identify certain wells in the group of 27 as having a high fluid level, and you state kind of how that's handled, and you list the fluid levels on page 8 of your testimony. Is that correct? Excuse me, page 6. Is that correct?
Yes.
Did you conduct any of those tests?
Did I conduct any of the fluid level tests?
Yes, sir.
No.
Okay. And other than listing those wells, am I correct in understanding that you base your listing here based on Mr. Jellick's testimony regarding the high fluid levels, correct?
Off of the fluid level tapes that your employee shot, yes, with Mr. Jellick.
Pardon?
Off of the employees for Prairie Gas that shot the fluid levels that Mr. Jellick witnessed, yes.
Okay. But as I understand, he is the principal witness as to the fluid level issues and violations. Is that a fair statement?
In this area, yes.
Okay. Do you agree that since the license was reinstated, Prairie Gas has been making substantial efforts to come into compliance with the penalty order in penalty order 3129?
They have
Objection
been,
calls for speculation.
He can describe what effort he knows about.
they have been turning in fluid or TAs on a more regular basis since they were suspended, yes.
Okay. And you are not aware of whether they've taken actions to produce the wells or taken any actions to get water under control in the wells, are you?
No, I haven't witnessed any of that.
Okay, fine, thank you. If I could have just a minute. I don't believe I have any more questions. Thank you.
Thank you. I believe we will move to commissioner questions at this time, and I will begin with Commissioner Keene if you have any questions for Mr. Meyer.
Thank you, Mr. Chair. Good morning, Mr. Meyer.
Good morning.
A couple of questions for me. With respect to all of these dockets and all of the wells, are they all gas wells?
Yes, they're all gas wells.
All of them requiring that fluid be pumped off of the wells? In other words, are there artificial lift jacks associated with all of these wells?
As far as I'm aware, I haven't looked at all these wells.
Okay, I can reserve that questioning for Mr. Jellick. Mr. Meyer, as I look at your direct testimony, and you need not bring it up, John, but as I look at page 2 and it sets out your background and work experience, you have some real world experience with serving with a cementing company in a variety of capacities. You were a pumper as well, and you've been with the commission since 1996. Is all of that correct?
Yes, sir.
All right. In that experience and in your experience, specifically with respect to your experience with the commission, when an operator's license is suspended, in your experience, are an operator's environmental responsibilities under our regs also suspended during the time of that license suspension?
No, sir. It's just they can't produce, but they can still work on their wells.
Okay. Are they not responsible, or are they not responsible for the containment of fluids, produced fluids and other oil field related fluids during the period of a suspension?
Yes, sir.
How about spills? Are they responsible in the event that there should be spills for any reason?
Yes, sir.
All right. I think, given your testimony, I will reserve most of the questions I have about the casing integrity issues for Mr. Jellick. I believe this time that's all the questions that I have for you, Mr. Meyer. Thank you.
Thank you.
Thank you, Commissioner Keen. Commissioner Duffy, do you have any questions for Mr. Meyer?
Thank you, Chair French. Yes. Mr. Meyer, looking at page 7, the top of page 7, your direct testimony. It states here, operator failed to meet each of the deadlines provided in commission staff's NOV letters. So my question to you, did the operator reach out to you to communicate about the issues being experienced as a result of the NOV? I mean, were you contacted? Did you meet the operator at the site? Tell me a little bit about that, your communication with the operator.
I personally didn't have any communication with them at this time. No emails or anything. I save all my emails in there for records. So no, I didn't receive anything or any phone calls at that time.
So no phone calls, no emails, no texts.
Not during this time. I did receive a phone call later on after their license was suspended on what they had to do on some wells for fluid levels. I told them they had to get them with Mr. Jellick to get their fluid levels witnessed, because I had denied, I can't remember, I had denied quite a few of them because they didn't have current fluid levels. They didn't submit their tapes with their fluid levels. So when I don't see their tapes, so I can go over their fluid levels and look at them to verify, I deny them, and to any company, I deny them and send them back until we can either witness them or they provide a fluid level tape for us to look at.
Okay. And then finally, in that same paragraph, further operator has not plugged any of the wells.
No, ma'am.
Okay, thank you. Mr. Chairman, that's the only question I have.
Thank you, Commissioner Duffy. I don't have much. I think just for my own knowledge, during a license suspension, if an operator gets a TA, an operator could avoid a TA penalty by returning the well to service. And that just means capable of producing, correct? They wouldn't actually have to produce in violation of a license suspension to avoid the TA penalty, correct?
Well, a TA is a temporary abandonment, and they can refile that TA with a correct fluid level or a new fluid level and send it in and avoid any problems on that TA.
Okay, so they've got multiple routes there.
Yes, they do.
Okay, that clarifies it for me. And then I had some questions. I think this may be similar to Commissioner Keene on the mechanical integrity test. The operator at page 9 of Mr. Ackery's testimony talks about some of the concerns he would have with performing mechanical integrity tests on these older wells. Is that something I should reserve for Mr. Jellick, or would you be able to answer staff's position on those comments?
I can answer them.
Okay. Well, I guess my first question would be, he states performing a mechanical integrity test can actually lead to creating a hole by pressuring casing up to 300 pounds on 30-plus-year-old casing when normal operating pressure is less than 90 pounds. Does staff share those concerns about performing a mechanical integrity test on the subject wells?
No, sir, because we have to establish that there are no holes in the casing. And if one happens while we're doing that, that means there is a problem with the well and it needs to be fixed.
Okay. So in your opinion, not performing the test is a greater risk than performing the test?
Our greatest resource is water. We can't live without water. If that's contaminated, it will bankrupt the company trying to fix it. So no, fixing a well, if they can't afford or don't want to fix a well, is minute compared to contamination.
Would it be fair to say that if staff had a reason to think that the wells were in that precarious of a position, that perhaps you would just recommend they be plugged?
Well, we leave that up to the operator. When we send these TAs out, it states they can plug it, produce it, or fix it, either one. We give them the chance to run a cast iron bridge plug, test their casing, and they can TA the well from that, or they can bring it back into production, or they can plug it. That's that way with every company. We give them all that chance because it's they're incurring the costs.
Okay, I appreciate that. I think that's all the questions I have. If there are no further commissioner questions.
Mr. Chairman, if I might.
Go ahead, Commissioner Keene.
Thank you very much. Yes, Mr. Mayor, let me ask you this question. You have experience, you work for Allied, you have experience in the field. If you know the answer to this question, please answer it. If you don't know it or have reservations about that, please acknowledge that. But to the best of your knowledge, when these wells were completed, were they completed as far as the cementing as alternate 1 or alternate 2 completions, or do you know?
Let me look here. They were completed as alternate 2. There's a check mark on the TA application, temporary abandonment, and it shows that the Floyd A was an alternate 2 completion. How it was completed.
Okay. What does that mean? What's the difference between alternate 1 and alternate 2? What does an alternate 2 completion mean?
It means that a top stage cementing job was done. This one looks like, and I'd have to go back in the records to see, but when they put the product, they set 242 feet of surface, And then they went in and cemented 4.5 to 2948 with 485 sacks, which sounds like they tried to cement it to surface, of which it doesn't indicate on here whether it circulated or not. That'd be other records I'd have to go through and check to be sure. But they tried to cement the long string in.
Okay, hence the use of 400 plus sacks of cement.
That much, yes, for that depth.
Sure. So basically, the difference between the alternate one and the alternate two is that the alternate two, when the production casing is cemented in, it's cemented from bottom to surface, ideally. Whereas in an alternate one completion, it's not cemented to surface. It's cemented, I guess, preferably around the area of the production to be produced zone and the anticipated perforations. Is that correct?
Yes, but there are areas in our district that don't require alternate two because they're not affecting the usable water. We don't have usable water. Further east, we don't have the problem we do out west. So out west, we have to do an alternate two completion with either longer surface pipe or circulate and cement from top to bottom on the production casing.
Okay. As between alternate one and alternate two completion, are there more potential environmental risks associated with alternate one completions than alternate two?
Again, it's going to depend on the area you're in, Commissioner.
Fair answer.
In our area, since 1986, you can't do an alternate one unless you set deep surface. And that's below the permium, which we call usable water. If they set surface below usable water, that's considered an alternate one. If they set shallow surface, which is 220 feet, then they have to do an alternate two, which is cement the top from the permium up on the production casing.
Very good. Thank you, Mr. Chairman. That's all my questions for Mr. Moore.
Thank you. If there are no more commissioner questions, I think we will move to redirect at this point. Mr. Marsh?
Thank you, Chair French. Mr. Meyer, I just have two questions that I want to make sure are clarified for the record. Did Prairie Gas ever respond or acknowledge the NOV letters between the time that the NOV letters were sent and the time that the penalty order was issued?
No, sir, not to my knowledge.
And do you still process temporary abandonment applications that are submitted by operators, even if the operator is suspended?
Yes, we do it all the time.
All right, thank you. No further questions.
Thank you. Mr. Meyer, it looks like you are finished and you may step down off the virtual stand. And
May I follow up commissioner questions with a brief redirect?
we will allow a brief recross.
Yeah. Mr. Meyer, you said you did not have any communications with the exception of one telephone. Would you agree that people in the field had frequent communications with your field personnel?
That'd be hearsay. I don't know. You'll have to ask Mr. Jellick.
So you don't know whether that occurred or not?
No, sir, I do not.
In your experience, would that be common for people out in the field to work with your inspectors?
Yes, it would. It could be, yes.
All right. Also, I think I blanked out briefly when Mr. Keene was asking a question of, are these wells all alternate to completion? Is that your?
I would have to go back through the records
Okay.
to look at each one. I just brought up the one, the Floyd on the TA application. It says it's an alternate to completion.
Okay. And that would be more common in the Greeley County area. Is that correct?
Yes, it should be.
All right. Thank you. I think that's all I have. Thank you, Chairman French.
Thank you, Mr. Thompson. Since I did allow a little recross, Mr. Marsh, do you have any redirect just within the scope of those couple questions?
Do not.
All right, very good.
Can I make one comment?
Go ahead, Mr. Meyer. I'll ask you a question of whether you have any comment within that.
Yes, the reason the field people, it doesn't matter if they have communication or not with Prairie Gas, I mean, that helps us, but they don't have anything to say whether the NOV letter, they don't send out the NOV letters, our office does. And our supervisor and with me, we go through each one of these to see if we can work with them and help them out. And if they don't communicate with us, we have no way of knowing what's going on or if they need help unless their office gets in touch with us. They may be in contact with the people, but that's not who they need to be in contact with when they're in trouble.
Thank you, Mr. Meyer. We are complete with this witness. You may step down. Mr. Marsh, you may now call your next witness.
Thank you. Staff would call Mr. Ken Jellick.
Mr. Jellick, good
Morning,
morning.
sir.
If you would raise your right hand, do you swear or affirm the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
Yeah.
Thank you. Mr. Marsh?
Thank you, Chair French. Mr. Jellick, can you please state your full name for the record?
Kenneth D. Jelly.
Mr. Jellick, by whom and in what capacity are you employed?
I am an environmental and compliance regulatory specialist with the Kansas Corporation Commission.
Mr. Jellick, what is your work address?
210 East Front View, Dodge City, Kansas.
Are you the same Ken Jellick who caused to be filed in this docket direct testimony consisting of 10 pages and 4 exhibits?
Yes,
Was this testimony created by you or at your direction?
by me.
Now that you are under oath, do you have any corrections or additions to make to your testimony?
I do not.
If I asked you today the same questions contained in your testimony, would your answers be the same?
Yes,
Do you swear the answers contained in your pre-filed testimony was and is true to the best of your knowledge?
yes,
At this time, I would move for the admission of Mr. Ken Jellick's pre-filed direct testimony into the formal record.
Any objection? Hearing none, the reference testimony will be moved into the official record.
Thank you. At this time, we would tender the witness for cross-examination.
All right, thank you, Mr. Marsh. Mr. Thompson, witness Jellick is yours.
Okay, thank you. Mr. Jellick, as I understand your testimony, which, and I'm referring to page 6, lines 20 to 22, your position is that the fluid levels you observed may give rise to concerns about the potential pollution of usable water and harm to correlative rights. Is that correct?
that's correct.
As it relates to the 3 wells at issue, Watson, Fecht, and you know the 3 I'm talking about, I assume.
Right.
Were any notices of violations or penalty orders issued which specified threats to pollution, to your knowledge?
Yes, I believe so.
And what such notices or penalty orders did you have reference to?
I don't have them handy right here. 82-3-111. Basically, they were high fluid level wells above the usable water.
Did you hear the cross-examination of Mr. Meyer about the notices of violations?
Yes,
And am I correct that you are referring to the words high fluid level which appear on those notices, correct?
correct.
I guess my question is, to what extent did the notices require correction of the fluids as opposed to simply meeting the requirements of KSA 82.3-111?
Could you rephrase that, please?
Yeah, let me see if I can help you out here.
Mr. Thompson, is there one of your exhibits you'd like us to pull up?
Well, that's what I was trying to decide. I apologize for the delay. I think my question is whether or not let's look at 111 again.
Is that, this is John Myers, is that the Meyer cross number 111?
Yes, and just so everyone understands, I pre-marked these and labeled some Meyer and some Jellic, and because I obviously didn't know for sure which would apply, so I would ask the commission to take in mind that I'm not trying to imply anything by the name of the person on the exhibit number. Do you have that in front of you now, Mr. Jellic?
Yes.
This was a response to an application for temporary abandonment in June of 2020. And it's one of those that lists high fluid level, but does not the notice state that pursuant to K.A.R. 82-3-111, the well must be plugged or returned to service or obtain temporary abandonment status by 7/16/2020. You see that?
I do.
And is there anything on that particular denial form which says they must take some further action to correct the high fluid level as opposed to the three categories inherent in 82.3.111 of plugging, returning to service, or obtaining temporary abandonment status?
I don't see that on that form.
Okay. There were some notices of violation, I believe, which you reference in your testimony as to some specific water issues, and I call your attention to your exhibit KJ-4, and I did send a copy of that to you, Mr. Myers, also, I believe.
Yes, I have it. Mr. Thompson, would you like me just to send all 6 potential Jellic cross-examination exhibits to Mr. Marsh at the moment?
Yeah, that's fine. I don't know whether I'll use them all or not, but
Okay, I will send them and I will pull up KJ number 4 on the screen. Hold on.
Okay. There are 3 notices of violation in your exhibit KJ-4. Do you see those?
Yes.
Those reference the Earl 1, the Fecht D 1, and the Watson number 1, correct?
Correct.
And we understand, I assume both of us, that those were the subject of some prior notices under 82-3-111 that were at issue in the license suspension proceeding. Are you aware of that?
Yes, sir.
Objection, relevant. Whether they're in compliance with 82.3.111 is not relevant to whether they need to have casing integrity tests done at this time.
Well, I could argue that, but I'll leave it to the chairman to rule on it.
I agree it's not relevant to that issue, but I will let you continue to see if you can establish some relevance.
Well, I guess my point is on exhibit KJ4, you specifically notify the operator of problems with the water formations and the possibility of casing leaks, right?
That's correct.
And are there any other such notice of violations alleging 82-3-104 to your knowledge in the 27 wells at issue in this case?
I would have to check on the 27 wells, but I believe there probably are. I can't.
But you don't know whether or not the notices of violations as to the 27 wells specifically relate to 82-3-104, correct?
I'd have to review those 27 wells. Mr. Myers could probably tell you that.
I apologize. It's been a while since I've had a commission hearing. Questioning the witness, I suppose I should move the admission of those exhibits, and I may have neglected to do that previously.
Well, I
Right.
was going to ask you at the end, because I don't think you've moved for admission of any of these, but correct me if I'm wrong. It looks like these are all exhibits that are attached to testimonies, which are already in the record. And so I think you could just use these as illustratives unless I'm wrong, unless any of these exhibits are not already filed within the record.
Well, some involve the penalty order and other orders, but I think those are all fair game also. Am I correct in that?
Yes, if they are all within the record, there's no issue of already citing to them. We would not need to admit them further into the record. Mr. Myers, John Myers, am I getting that right?
Well, yes, if they are already in the record in one of these 4 consolidated dockets, there wouldn't necessarily be a need to admit them. I will say, though, given that Mr. Thompson has been cross-examining and has identified them as the specific exhibit numbers, there might be some utility in admitting them, even if they were duplicative of something that's already on the record.
That's a good point, Mr. Myers. Mr. Thompson, do you have reference to which of your exhibits you have been referencing and would like admitted into the record?
Well, certainly I ask about exhibit 111, but I believe that is an exhibit to Mr. Myers' testimony, but I would move that into evidence if necessary.
Chair French, this is John Myers. If I may, I have a list of them, given I was emailing them to Mr. Marsh and Mr. Thompson. It looks like in Mr. Myers' testimony, he used Meyer cross exhibits 110, 111, 112, and 114. And so far in cross-examining Mr. Jellick, he has used Jellick's exhibit KJ-4, which is already part of Mr. Jellick's testimony.
That sounds correct to me. Mr. Thompson, does that sound correct to you?
Yes, it does. To the extent I have not already done so, I would move the admission of those particular exhibits that I referred to.
Objection.
Okay, they will be admitted into the record. Do you have further cross-examination for this witness, Mr. Thompson?
Yes, I do.
Okay, go ahead.
I would like to ask you, Mr. Jellick, if you have seen the notice of penalty assessment as it related originally to the Watson and Earl wells, and that has been marked as Jellick Cross Exhibit 101. Perhaps we could pull that up. We had a chance to review that.
Yes.
And if you turn to page, or look at page 4 of the penalty order, it states that the operator should plug the subject wells or return the wells to service or obtain TA status for the wells if eligible, correct?
Objection. What's the relevance? We're talking about a 111 penalty order that's not at issue in these proceedings.
Well, they're part of the consolidated issues, and I think the comparison of the penalty order with relief being sought is something that I would like to explore.
You can explore it. Objections overruled.
All right, thank you. That penalty order was the subject, and obviously the record will reflect, I believe, if you would agree, that Prairie Gas withdrew its request for a hearing, and thus the penalty order became effective, correct?
Correct.
And the same is true, is it not, for the penalty order on the fetch number 1, if you can recall?
I believe that's correct.
And I believe that is shown in Exhibit 102. Is that correct?
That's probably correct.
And I would move the exhibits of 101 and 102 into evidence, if necessary.
Any objection?
Objection.
They are admitted. Thank you.
Now, the license suspension dealt particularly with those, among others, those 3 wells, and the license suspension was lifted as to those wells. Is that correct?
Objection outside the scope of his testimony.
I'm going to overrule that.
You have the question in mind, Mr. Jellick.
Your question again, please.
My question was that after the license suspension was lifted, let me rephrase it, Prairie Gas did comply with these orders and returned them to, in those 3 wells, returned them to service, correct?
That's not correct.
Okay. Did the license suspension was lifted, however, as to those 3 wells, correct?
I believe that's correct.
And I'll save my comments on that for legal argument in the brief. I don't think I need to go into that further. there's been no penalty assessment with regard to the 3 wells which had the notices about, let me rephrase that. On your exhibit KJ4, has there been any penalty orders issued with regard to those wells? I apologize, I've got so many exhibits here. Let me rephrase it. KJ4 is a notice of violations on 3 wells that we looked at, citing K.A.R. 82-3-104, correct?
Okay, correct.
And has there been a penalty order issued as it relates to a violation of K.A.R. 82-3-104?
Objection outside the scope of Mr. Jellick's testimony, plus if a penalty order is going to be issued, it's going to go through the legal department, not Mr. Jellick.
I think if he knows, he can answer.
Yep, I'm going to overrule the objection. He can answer within his personal knowledge.
I have no personal knowledge of it.
Okay.
Mr. Chairman, we're not seeing Mr. Jellick's face. Is there a reason why? There we go. Okay, thank you.
Sitting too close to the screen, so.
Oh, okay, all right.
Or
Thank you.
if y'all are able to point the camera down a little, that'd be great. Or just look up. Thank you, Commissioner Duffy.
I want to continue to focus on the 3, the Earl number 1, the Fecht number 1, or the Watson number 1, and also the other wells at which listed high fluid levels. Are you aware of any complaints from landowners or mineral owners as about the pollution of water under any of those wells?
No, not that I can recall right now.
Has there been any testing of the water in the areas which you contend there's high fluid levels which endanger the potable water supply?
Testing for what?
Testing to whether or not the water has been infected or not.
The water's been tested, not necessarily been infected, but it's been tested for chlorides and other contents that could cause the excessive corrosion.
But has there been any testing of whether or not the water that is in the water table used by, that's potable water, has been found to be inappropriate for consumption?
Not that I'm aware of.
Have there been any orders or penalty orders issued containing specific findings or of fact or conclusions of law, if you know, related to the issue of defective casing or casing leaks?
You're going to have to rephrase that.
Have there been any penalty orders? Well, are you involved at all in the preparation or input into the issuance of penalty orders?
Not really.
Okay. Do you review them?
Once in a while, but it's not my primary job. Once in a while, I'll get a chance to look at them.
Okay. So I'll move on. You have indicated you have concerns about the potential pollution of usable water and harm to correlative rights. And you say a casing integrity test is needed. What is involved in the casing integrity test that you say is needed?
A casing integrity test is performed by isolating the producing perforations by a bridge plug set above them, and then filling the casing with treated water and pressuring up the casing to a minimum of 300 pounds for 30 minutes.
Does the well have to be shut in prior to that test?
Yes,
For how long?
I said 30 minutes.
Has to be shut in for 30 minutes?
The test has to be 30 minutes,
Okay. How long does the well have to be shut in prior to the test?
long enough for the equipment to be pulled out of it and the bridge plug to be run in, and then the equipment returned. It could be a couple days.
Are you familiar with, I assume in your area of expertise, the Bradshaw Field rules?
As far as what?
Well, as far as whether or not the wells in the Bradshaw Field are required to be shut in prior to annual tests.
Objection. What's the relevance of annual tests to casing integrity tests?
Mr. Thompson, any response?
Right. I think that what I'm getting at is the tendency in that formation to water out quickly, which appears in the and which I think would come into play with the casing integrity test.
I'll overrule the objection.
What is the difference between an annual test and a casing integrity test?
The annual tests are actually gas flow tests to determine the capability of the well and to assign allowables to the well. Has nothing whatsoever to do with the casing integrity test. That is simply proving or disproving the integrity of the casing. The deliverability test is strictly to do with gas allowables.
Okay, so let's go with casing integrity. They're going to have to be shut down for several days at a minimum, right?
At least probably a day and a half to 2 days.
And during that process, would not the water occur that it would, in the Bradshaw Field, they water out quickly?
Well, sir, the wells in question are not producing now. So it would be not a matter of shutting anything down, they're already shut down.
Well, haven't they been held to be capable of producing by virtue of the fact that the license suspension was lifted?
Capable of producing water, but not capable of producing gas.
Do the rules require production of gas to meet the requirements of 82-3111?
They're gas.
Objection outside the scope of Mr. Jellick's testimony.
Follow up to his answer.
I would say I'm going to give you a very short leash here because you're basically asking for a legal conclusion at this point, and the law is what the law is. You can make that argument in your brief.
Okay.
So I will overrule the objection, but with that direction.
Do you recall the question? I don't recall the question.
Okay, so go ahead and repeat it.
Do the during the casing integrity test, would not the wells experience incursion of water by virtue of the nature of the Bradshaw Field?
Not really. We're simply filling the casing up with water.
Okay. It wouldn't. they wouldn't tend to water out as they would during a annual test?
They wouldn't be producing. There's nothing to water out.
Well, it's your,
Annual test and casing integrity test confused, two separate issues.
I understand that. But you say they're not producing, but they're capable of producing, correct?
I can't say that they're capable of producing.
Well, isn't it your position in communications with the staff or the communications with Prairie Gas that if gas isn't being sold, it's not capable of producing?
They're gas wells. In our database, they're gas wells. They need to be capable of producing gas.
But don't you take the position that they have to be selling gas?
To be considered producing,
But not capable of producing?
not necessarily, they could be TA, temporarily abandoned. That means they'd be capable of producing.
If I may have just a moment here. I have no further questions.
All right. But at this time, we will turn to commissioner questions, beginning with Commissioner Keen. Do you have any questions for Mr. Jellick?
Yes, thank you. Thank you, Mr. Chairman. Good morning, Mr. Jellick.
Yes, sir.
If I can start as I did with Mr. Meyer, I'm looking, and you need not bring this up, John. I'm looking at page 2 of your direct testimony of August 20th, 2021. And as I look at your educational background and work experience, if I'm understanding it correctly, you have a bachelor's degree in geology from K-State. You worked for 10 years for Dow, basically engaged in well cementing, acidizing, and fracturing. That was for about a 10-year period. And then for 21 years after that, you were an engineer and superintendent for Helmerich and Payne. And since 2004, I've worked for the commission as either a PERT or an ECRS. Is that a correct summary of your background?
Yes.
It looks to me like you have a fair amount of real world experience prior to, or private sector experience, pardon me, prior to coming with the state. Mr. Jellick, let's focus. I've deferred the questions about casing integrity and the issues having to do with that to you. So let's kind of cut to the chase and talk about that subject if we can, and allow the commission to lean on your experience and benefit from it if we can. We've heard the phrase high fluid level repeatedly expressed here this morning. It appears throughout all of the pre-filed testimony, and we've heard it referred to here this morning. What does that mean? What does high fluid level mean?
Okay, first of all, when we talk about high fluid level, we are speaking about fluid level from the surface down to the fluid level, okay? From ground level down to the fluid level. In other words, if a well has a fluid level of 1,000 feet, that means it's 1,000 feet down to the fluid level. That's not the fluid level that's in the well, okay? And when we refer to a high fluid level, we are referring to fluid level that is above, it's either at or above our usable water, which we consider the top of the Permian section. And that is, there's some Dakota and Cheyenne sands in that interval that feedlots use. They can use it for irrigation. It's really not potable for human consumption, but it's okay for livestock consumption and irrigation. Okay.
Thank you. So what is the environmental concern presented by wells having a high fluid level?
typically a high fluid level is caused from a casing leak. And the reason we know this is the bottom hole pressure of the chase formation is not sufficient enough to lift a column of fluid as high as we're seeing on these high fluid levels. These wells were drilled 20, 30, 40 years ago. Initial bottom hole pressures were in the 400 to 500 pound range. Now the bottom hole pressures are maybe 100 to 200 pounds. At the most, we might get a fluid level of 500 or 600 feet in the well. That's about all we can expect anymore due to the depletion of the reservoir. So when we see a high fluid level, that tells us that we probably have a casing leak and it has fluid is coming in from an external source. It's going down into the producing formation. And as a producing formation charges up, plugs off, whatever, it'll start building inside the production casing. And as it'll continue to build till it reaches the bottom hole pressure of the Glorieta Cedar Hills corrosive zone that we've been speaking about, which is about 420 pounds.
So if I can kind of summarize what I understood you to say in so many words, a major environmental risk from a high fluid level well, if in fact the cause of that is from a casing leak, is the commingling of potentially fresh water with produced waters and the contamination of potable water areas. Is that correct?
That's correct. It's a highly corrosive water from the casing leaks. In fact, that's why it caused the casing leak in the first place, because it's corrosion from the outside in causing the problem. And we have two issues. We don't want it to continue to corrode the casing up high and get into our usable water. And number two, we don't want it invading the producing zone and affecting offset operators' correlative rights.
Thank you for that answer. Is the risk of this sort of environmental concern present in the areas where the operator's wells subject to these various dockets are located?
Say again.
Sure. Is this risk having to do with these environmental concerns you're alluding to? Are these risks present in the areas where the operator's wells that are subject to these dockets are located?
Yes.
How do you determine whether a well has a high fluid level?
We shoot the fluid level with an echometer sounding device. It's a device that you connect to the annulus of the well. You set off a charge and it sends a sound wave down the hole and it marks the tubing collars. And then you count the joints of tubing down to the fluid level. It's a pretty accurate device.
Are you personally familiar with the Earl #1, the Fecht D #1, and the Watson #1 wells?
Yes.
Have fluid level determinations been run on these wells to date?
Yes, several times.
And what were those results? Summarized briefly.
All three of them were high fluid level wells.
Okay. As I understand it, and I did ask this question of Mr. Meyer, it appears to me that all the wells that are before us today are gas wells, are they not?
Yes.
I know you had some rather extensive photography of ABB meters throughout Southwest Kansas that were the operator's meters, and I presume those were gas meters that you were photographing, were they not?
I'm sure there were, yes. All of these wells in question, by the way, are equipped with pumping units. They have tubing in the hole and rods and pump in the hole. And the purpose of that pumping unit is to remove water from the wellbore so that wells can produce gas out the casing. Two separate streams, a gas flow and a water flow.
You've just answered the next three questions I had. Let me take a look at my list. You remember the dates, Ken, when the high fluid level tests were last run? What's the most recent dates? Do you recall those?
It's on my last report here. I can give that to you on all three of the wells. All right.
Just for the record here, if you would, in this testimony.
On the FET, it was 1/6/21. On the Watson, it was I can read my writing. Like 5/5/21. On the Earl, 1/6/21.
Mr. Jelly, with respect to these three wells, do you know whether they were alternate one or alternate two completions for cementing?
They were all alternate two completions.
That was the last statement.
Go ahead. They're all alternate two completions, you say?
They're all alternate two completions.
Okay. So in a case like that, just based upon your experience, it's kind of interesting because you have an alternate two completion. So at least in theory and in practice, you have a cement sheath between the bore and the outside diameter of the production casing, all the way from the bottom of the well, at least for purposes of this case, from the top of the perforations all the way to surface. Yet your tests are indicating that we have a casing leak. So is there what's the probability? What would cause that to happen? Is the probability that there's some part of the casing that was not basically totally protected by the cement?
That's correct. There could be several reasons for that. Number one, if the hole that was drilled is not perfectly vertical, when you run casing in the well, it can lay against the side of the hole, number one. Number two, if the cementing that was used was not performed properly, maybe it was not cemented 360 degrees around the well. Maybe it was not centralized properly. Possibly, if the cement was against a highly salt reservoir, it may not have set up for quite some time because it retarded. So there's a multitude of reasons, and all it would take is one little small interval, just a few inches that wasn't cemented properly to cause this casing leak.
All right. Mr. Jellick, I thank you for your testimony. And Mr. Chairman, I have no further questions at this time of this witness.
Thank you. Commissioner Duffy, any questions?
Yes, if I could. Good morning, Mr. Jellick. In your testimony, you, on numerous pages, you start out by saying, I performed a lease inspection. So what prompts a lease inspection? In particular on these wells, what prompted a lease inspection?
These particular wells, I believe it was, I'd have to refer back, but I believe they hadn't produced for quite some time. So we physically had to go to the well and inspect it and see what the issues might be, why it hadn't produced. That's what initiates a TA application in the first place that we would send to the operator on, hey, we need to, this well hasn't produced for a year. We need to file a temporary abandonment. We need to produce it. We need to plug it.
So typically, to initiate a lease inspection, there's a reason why. And in these instances, is that correct?
It's not always, not necessarily. We do routine lease inspections. also,
Okay,
Randomly, at our discretion. We routinely we have the authority to do lease inspections wherever we want to do lease inspections. So on these,
Okay.
I believe on these particular 3 wells, if I recall, is because they hadn't produced. I don't believe any of them have produced since 2015 as far as producing gas.
okay, all right, since 2015. And do you know, did the operator own those wells back in 2015?
Not this operator,
Okay, all right,
previous operator.
all right. When you go out and do a lease inspection, are you contacting the operator at all to let them know I'm going to be out, or you just go out on your own?
No, we're not required to do that.
Okay. During your lease inspections, did you have cause to run into the operator or someone performing work on these leases?
Not on these leases. I mean, yes, we routinely run into the operator's bumper out there, so to speak, but on these leases, I didn't initially.
When you do a casing integrity test, does it require the operator to be on the site or a representative of the operator?
We would prefer that. We would prefer that the operator have a representative there to witness the testing, and in probably 95% of the cases we do.
Okay. All right. When you talk about the corrosive nature of the fluids, is that something that is in particular related in your district area, that it is so corrosive?
It's pretty much common throughout the western half of Kansas, not just in our district. Other districts have the same issue. This is this particularly reservoir, this corrosive reservoir, it's called the Glorieta or the Cedar Hills, covers a wide swath of the western half of Kansas.
Okay, so the corrosive nature is just not limited to the wells that we're talking about today. Then I'm assuming it's fairly common throughout, as you said, that area of the state.
Yes.
So after about 30 years after there's been work on the well, is it, I think you had mentioned that sometimes that the corrosive nature will eat through the material, correct? Is that pretty common?
It will actually corrode the steel casing of the
Corrode
well.
the steel casing, thank you.
Yes. It takes longer. Sometimes it takes longer and sometimes it's not so long. In my experience, have happened in 6 months. Sometimes it might take 20 years.
Okay. Mr. Jellick, how long have you been working in the Dodge City District Office?
17 years.
Okay, all right. All right, Mr. Chairman, those are all the questions I have. Thank you.
Thank you, Commissioner Duffy. Mr. Jellick, I'll just ask you the same thing I asked Mr. Meyer, just to see if you had any additional thoughts on it. And I'm referring to page 9 of Mr. Ackery's testimony, where he states his concern that performing a mechanical integrity test on these older wells could be a risk. In your opinion, is that ever a reason not to perform a mechanical integrity test? And would it be a reason not to perform one in this case?
There would be no reason not to perform one if this casing originally, when it was ran in the well 20 or 30 years ago, was the burst pressure on it is 6,000 or 7,000 pounds, 6,000 or 7,000. If it will not hold a column of fluid with 300 PSI on it, then it's about ready to go anyway. So we have to, I don't know what your original question was, but no, it's not an unreasonable request to test a well to 300 PSI.
Okay. So it would be your opinion that if it's in a state where it couldn't hold the mechanical integrity test, then it's probably a good candidate for plugging anyway.
That's up to the operator. Operator could plug it, operator could repair it. Actually, those are about the only two options unless they elected to try to produce the casing leak water along with the formation water,
okay,
which is not a good idea.
Okay. All right. If there are no further commissioner questions.
Chairman, again, if I may, I
Mr. Keen.
beg your indulgence, if I could follow up maybe with one question to Mr. Jellick. Mr. Jellick, my question relates back to a question asked of you on cross-examination by Mr. Thompson. I think he was questioning about, I think, the methodology involved in conducting a casing integrity test. And he was concerned, I think, I'm not trying to misparaphrase him at all, but I think he was asking a question about whether or not if particular zones that produce prolific amounts of water could interfere with the conduct of those tests. And you indicated it could not. And I think is it the reason it could not? Is it not? Is because the casing to be tested, you have a packer in there that's above the perforation. So any other holes that they're going to be, or any other means of ingress or egress from the casing that they're going to be, will not be manned. It's going to be something that's what you're testing for. It's a potential hole. Is that not correct?
That's correct, and I didn't explain that very well, but you're exactly right. The fluid would be contained above the bridge plug and would not ever go into the formation unless you release the bridge plug. Otherwise, it's all confined within the casing itself.
Yes, and the production and the fluids from the formation, likewise, they couldn't. The bridge plug keeps the fluids that are coming in from the producing formation contained below the packer also, right?
Correct.
Okay, thank you, Mr. Chairman. That's it.
All right. If there are no further commissioner questions, Mr. Marsh, would you like to do any redirect based on the scope of cross and commissioner questions?
If I may, Chair French.
Go ahead.
Mr. Jellick, during your testimony, you say that, whenever there's these casing holes, that water is flowing into the casing. Is it safe to assume that corrosive water will also find ways to eat out and go out at different locations from the casing?
That's correct.
Okay. And Mr. Jellick, what is the current status of the Earl #1, Fecht D #1, and Watson #1 wells?
To my knowledge, they're still inactive and shut down.
So to your knowledge, these wells have not been dewatered or returned to service since the last time you witnessed them nearly a year ago?
No, sir.
No, thank you. No further questions.
Let me ask, there was some pretty extensive commissioner questioning. So Mr. Thompson, do you have any recross that you'd like to ask as a follow-up to commissioner questioning? I'm not hearing anything from Mr. Thompson. You're on mute if you're trying to respond. All right, we're gonna move on then. We have reached the end of staff's witnesses. We do have one witness for the operator. We're at 12:20. I'll tell you, my inclination is to just try to get through this fairly quickly. Would anybody object to taking maybe just a 5-minute break for everyone to take a restroom refreshment break and then just move forward through the rest of the hearing? Or is there any reason why we have to take a lunch break at this point?
I would appreciate a short restroom break and agree we could move forward.
Very good. Well, let's break until 12:25 and then we will reconvene. We are now off the record and in recess until 12:25.
Parties, make sure you are on mute while we are in break. I believe we will continue to stream throughout the break. Thank you.
All right, I've got 12:26. I do not see everyone here on my screen. All right, Commissioner Keen, pop back. Kelsey, you're here. Could everyone just turn their video on for a moment to let me know that you are here? Looks like, well, we've got two of the three commissioners. Commissioner Keen, could you please turn your video on if you're back?
I'm
All
back.
right. Very good. Okay, if everybody's ready to begin, we will. We are now back on the record in this evidentiary hearing. We have completed examination of staff's witnesses. So at this time, we are ready for the operator. Mr. Thompson, you may call your witness.
As I call Ian Acree, and Mr. Acree, will you click your video and sound?
It should be on.
Okay, there we are.
Very good. Before I return you to your counsel, I'm going to swear you in. Mr. Acree, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. Mr. Thompson?
Yes, please state your name, please.
Ian Acree,
And what is your business address?
114 East Fifth Street, Suite 100, Tulsa, Oklahoma, 74103.
I'm going to shut a door so we don't have any. I wanted to avoid cross sound, and
I appreciate it.
maybe that'll avoid Mr. Kelsey's concern that I'm coaching my witness too. I don't know. Are you the Ian Acree who proffered direct testimony in this case?
I am.
And you've sworn that it was true, and do you affirm everything that is in there true and correct, with the exception of a few corrections I'm going to call to your attention? Is that correct?
That's correct.
I would first call your, and most of them are my faults, but first call your attention to the cover of your testimony, which appears to be dated September 24th, 2011. I'm assuming it was 2021. Is that correct?
Yes, sir.
And on page 2, line 1, on page 1, line 2, you had a business address, which I think you need to change for your current address. Is that correct?
Yes, sir. It's the 114 East Fifth Street, Suite 100, Tulsa, Oklahoma, 74103 address.
Okay. And on page 3, line 3, I believe the testimony was there was at least 15 wells that had been granted TA approval. Or it may have said 12. I can't remember. What is the correct number according to your understanding today?
The testimony stated 15 wells had approved TAs, but it is only 13 wells.
Okay. And on page 3, you reference Exhibit A of your testimony. And do you wish to correct that as it relates to one well?
Correct.
And which well is that?
I think it's the Fecht.
Well, let me, on that exhibit, it has the Cliff number 19 and does not show TA approved. In fact, should that reflect a date for TA being approved?
You're correct.
Okay, fine. And I think,
Sorry, Mr. Thompson, just for my clarification, we're making a correction to Exhibit A, not to the testimony on page 3.
testimony on page 3 should be corrected from 15 to 13. And
I
on
got that.
exhibit A, it shows, I think, 12 wells having TA approval. And it should also include the cliff number 19, which he references should show a TA approval. And I think I went over that with Mr. Meyer.
Okay.
I apologize for this, but on page 8, lines 1 through 4, there is a reference to an exhibit C. Do you see that?
Yes, sir.
There appears to be no exhibit C on this. I'd like to blame someone else, but I probably can't. But it references notices of violations of K.A.R. 823-104. Does that reference the same as exhibit KJ4 that we covered with Mr. Jellick and Mr. Meyer of the
It
3
does.
notices of violations?
Yes, sir.
All right, thank you.
So, Mr. Chairman, can I just ask, when he was on page 3 of the testimony, and he said, he was talking about after the clarification of the number of wells, the next item had to do with the fact that there is nothing, right? You're referencing Exhibit A.
They were making a correction to Exhibit A. Is that correct, Mr. Thompson?
Yes.
But it doesn't have anything to do with the Fecht, F-E-C-H-T.
No.
Oh, okay. All right, very good. I was unclear on that. Thank you. I apologize.
With the commission's approval, I would like to supplement the direct testimony with just about 4 questions, which I think came up about who owns the wells and when they were acquired. Just a little bit of very little history. If that's out of order, so be it.
Well, yeah, I think we're going to stick,
Okay.
our typical rules are that all direct has to be pre-filed. Now, if you can weave it in within the scope of the questioning your witness receives, I'll certainly provide some leniency there.
Sure. No problem. That's what I figured, what I assumed, but I appreciate it. I tender the witness.
Before you tender him, we do need to make sure we admit his testimony as corrected into the record, if you'd make that motion.
I would move that we admit his testimony as corrected into the record.
Any objection from staff?
No objection.
All right, the reference testimony with corrections will be admitted. You may now tender your witness.
I do so. Thank you.
All right, Mr. Marsh, you may proceed with cross.
I don't have any questions for Mr. Acree. Chair French, you're still on mute. Steve.
Dang. For as many of these as I've been in, still once a week at least. All right, commissioner questions. I will begin again with Commissioner Keene.
Thank you, Mr. Chairman. Good afternoon, Mr. Acre.
Good afternoon.
I think we've at least established in terms of the opinion of our staff that all of these wells are gas wells. Is that correct? All the wells that are germane to all of these dockets, they're gas wells.
With the exception of one, I believe, well, all of them are, yes, all of them are permitted as gas wells. I think we have one that does produce oil. But specific to this docket, you're correct.
Okay. So I guess my first question would be, let's focus a bit on the 3 wells, the Earl number 1, the Fecht D number 1, and the Watson number 1, the 3 wells that the staff is contending should be subjected to casing integrity test. My question to you is this: does the operator contest or acknowledge that these 3 wells have holes in the casing?
Well, I think we can test that there's holes in the casing and we also believe that we have brought them into compliance. I'm not sure which specific code it falls under, but that we brought them into compliance by restoring them to production.
Okay, let's talk about that more specifically. I'm looking now at your direct testimony. I'm on page 5, and John, it might be helpful if you could do some screen sharing on this one.
One moment.
Yes, this is the page. Mr. Acri, let's take a look rather specifically at lines 6 through 9 of your testimony on this page.
Yes, sir.
And for the record, I'll read what your testimony is, and then you can tell me whether I'm reading it correctly. It says Prairie Gas sought to return many of the wells to production, and producing wells protect fresh water by removing fluid from higher levels of the annulus and maintains fluids below the depth of any threat, unquote. Did I state correctly what appears on line 6 through 9 of your direct testimony of September 24th, 2021?
Yes, sir.
In connection with your answer to my first question about whether or not you would acknowledge or contest that these 3 wells in particular had casing leaks, and you gave me an answer there that I thought was somewhat analogous to the lines I've just read from page 5 of your direct testimony. Toward that end, what I would appreciate is, can you embellish for us a little bit about what you mean about what you said, either in response to my prior question or in connection with these specific lines of your testimony? What do you mean by that? What are you getting at?
Sure, I'll do my best. And but effectively, when we withdrew the penalty order in at the end of 2020, we spent somewhere between $50,000 and $100,000 to work over the wells and restore them to production. General workover, pulling rods, tubing, changing pump, repairing electric, and began to produce them. We produced them over a period of time. December, January, February, and even into March. Our field personnel remained in constant contact with Mr. Jellick, and who performed a number of inspections during that period, all of which time we produced water and reduced the fluid level. And just as Mr. Jellick testified today, he took the position that even though we were producing fluid, from the well and had reduced the fluid level within the annulus, that the well was not producing gas and therefore contended it was not brought into compliance.
Okay, well that's not really even close to the question I'm asking. So let me ask the question again. I'm asking you to tell us within the confines of lines 6 through 9 what you mean when you say that by returning the wells to production. I'm paraphrasing what you're saying now, in fairness to you. By returning wells to production, the producing wells protect the fresh water by removing fluid from higher levels of the annulus. How does that protect the fresh water? Explain that to me.
Well, if there were a hole in the casing, and we maintain the producing, as Mr. Jellick noted, producing the water from the hole and or the formation fluid at the same time. By doing so, you would keep away the produced water away from the freshwater formation.
Correct me if I'm wrong, but to reach that conclusion, is it not necessary for you to presume a priori that well is being produced 24/7, 365 without interruption?
Well, not necessarily. It would. Oh, I'm sorry. Go ahead.
No, I was finished. Go ahead, please.
Okay, I apologize. It would depend on what the entry rate of the fluid is relative to if there was a hole.
Granted, that's very true. If the entry rate was such that it was very rapid. Well, let me ask you another question. I'll lead up to that. Does Prairie Gas, does your company operate or own in the vicinity of these wells pulling units?
No, they do not.
So basically, when wells have to be pulled, you rely upon third-party contractors. Is that correct?
Yes, sir.
Okay. In your recent experience, when you have to pull wells, are those pretty easy to come by? Can you pretty quickly have those folks come out to take care of your wells?
Well, I would say pre-pandemic, it was easier. There was more labor available, more companies in business. I would say it's progressively gotten harder. You have to get on a list. But there are available service companies.
Okay. So the likelihood is that if a well has to be shut down because you're awaiting servicing, either for a rod or tubing job, that it could be days, weeks, a month before someone got to that well. Is that not conceivable?
It's conceivable.
So my point is, let's say that we have hypothetically a well that has a casing leak, a whole casing leak, and that the fluids that are entering through that casing leak are somewhat prolific. And you have that well shut down for mechanical reasons. It needs a new pump. You have a hole in the tubing. You have to do something to repair that well. How is it that that fluid entering the bore wouldn't commingle from the casing leak, wouldn't commingle with the produced fluids and incur basically a substantial risk that it was going to pollute the freshwater resources that were in the vicinity of the home?
Well, hypothetically, I mean, in your example, you're correct. It's possible.
Because a hole in a producing well like this, when you have some of these zones that have the corrosive potential to which Mr. Zellick alluded, I think it's the environmental concern that sort of situation creates that is an underlying reason why you have the regulation that prescribes that the well either be repaired, plugged, or returned to service. There's a whole variety of things here, but if you see what I mean, there's a potential concern here that.
Yes, sir, and that's why we chose to.
Let me finish my question. Then I want to hear from you, please. But just simply producing the well would be a stopgap measure at best, would it not? Pardon my interruption.
Well, if you maintain production on it, it should protect it. But if you were to shut it in for extended periods of time under the hypothetical that you described, that would be correct. I would agree.
Okay. So again, just to kind of reiterate from my first question, if I could, let me start a different place. You were present at the hearing, were you not, throughout the testimony of Mr. Meyer and Mr. Jelly?
I was.
Okay. And did you understand some of the questions I was directing toward Mr. Jellick with regard to the testing that he performed on these 3 wells?
In general, yes.
Yes. And that it was his contention, based upon that testing, that these wells, each of these 3 wells had holes in the casing. You recall that testimony?
Generally speaking, yes.
Okay. So basically, it's your testimony that notwithstanding his testing and his conclusions from that testing, that these wells do not have holes in the casing. Is that your opinion?
I'm sorry, can you rephrase the question?
Yes, I'm asking, notwithstanding the testimony of Mr. Jellick and the conclusions he reached based upon his test, am I understanding that it's your conclusion that these wells do not have holes in the casing?
Not trying to be difficult. I just want to make sure I answer properly. Is it my testimony that there are not holes in the casing based on Mr. Jellick's testimony?
No, I don't. No, I'm not asking you to judge Mr. Jellick's testimony at all. I'm not asking you to do that. Let me ask the question directly as I can. Is it your opinion that these wells do not have holes in the casing?
I don't have an opinion one way or the other regarding the Fecht or the Earl. Regarding the Watson, we found where there was a backflow valve, that the backflow valve was broken and all the water we were pumping into the service tank was backflowing back into the well. And once that was corrected, and I believe was witnessed by Mr. Jellick, we didn't have high fluid level issues on the Watson #1. I don't have an opinion as to the Fecht D1 or the Earl one, other than that we were provided a notice, and the notice said to either produce it, plug it, or obtain an acceptable TA. And we deployed capital into restoring those to service because we thought that was complying with the order.
Okay. Mr. Egley, I appreciate your testimony. I have no further questions of this witness.
Thank you.
Commissioner Keen. Commissioner Duffy, any questions?
I have no questions of this witness. Thank you.
Thank you.
I suppose the only question I would have is, you obviously heard my questions of the staff witnesses, asking them to respond to your statements that, if I'm going to try to paraphrase here, but I believe you were saying it's more of a risk to perform a mechanical integrity test on these wells than that perhaps it would be better just to return them to service, that would be less risky. And I believe you heard staff's disagreement with that. I just, in fairness, would like to offer you the opportunity to offer any further commentary on that. I'm not necessarily asking you to reiterate your position. If you just disagree, I think you can just say that. But if there is something you think was misstated, give you this opportunity.
I appreciate that. I disagree, and I would just volunteer that even a well that still has casing integrity of anything, and so long as it's protecting the fresh water, is still usable casing, and that would just be, that's just my position, I guess.
Okay, thank you. I don't believe I have anything further. Mr. Thompson, do you have any redirect for this witness?
No, I do not.
All right. Well, I think Mr. Acree, you are done and may step down virtually off the witness stand.
I appreciate it. Thank you.
Let me pull up my script here. It does look like the parties have asked to make brief closing statements. So we will move to that at this time. Mr. Thompson, would you like to make a brief closing statement?
I think I expressed the views and the analysis I would in my opening statement, and I don't think a closing statement is necessary.
All right. Mr. Marsh, do you need to make a closing statement?
If I may, Chair French.
Go ahead.
May it please the commission. Once again, the two issues in front of the commission today are, one, whether the Earl #1, Fecht D #1, and Watson #1 wells need to have casing integrity tests conducted upon them and or be repaired or plugged. And then the second issue is all matters related to the penalty order in docket 21-3199 and operators' request for hearing thereon. In regard to the first issue, the commission received evidence from Mr. Ken Jellick, who has a degree in geology from Kansas State and has decades of oil field experience. In his testimony, you could see that the Earl number 1, Fecht D number 1, and Watson number 1 wells have high fluid levels above usable water, as well as dramatically changing fluid levels within each of their well bores. Further, Mr. Jellick also provided an exhibit, specifically exhibit KJ-3, that compared fluid levels in these wells to other reported fluid levels in the area of these wells. As you can see in that exhibit, there's a dramatic difference between the fluid levels of the Earl, Fecht, and Watson wells compared to the wells surrounding them. Additionally, we know that there is a highly corrosive formation that regularly affects wells in western Kansas. We also know that based on reservoir pressure in that formation, a casing leak can affect both correlative rights and usable water. There's nothing in the operator's testimony that refutes the facts laid out by Mr. Jellick, and staff believes that has put on more than enough evidence to show that the Earl number 1, Fecht D number 1, and Watson number 1 wells more likely than not need casing integrity tests. In regard to the second issue, the commission received evidence from both Mr. Meyer and Mr. Jellick. In their testimonies, you can see several different ways that these violations came to their attention. However, regardless of whether the violation came to their attention as the result of a denied temporary abandonment form, through a file review, or through a field inspection, the results were the same. They found a violation. They sent a notice of violation letter to the operator. The operator ignored staff's letter, and a penalty order was issued. While operator has brought some of the wells into compliance since the commission's penalty order was issued, staff does not believe that it is appropriate to give the operator relief for doing what the commission has ordered it to do. Therefore, staff believes that it's met its burden that more likely than not, these violations occurred. Additionally, operator's testimony does not present any evidence that these violations did not occur and had many inaccuracy as pointed out in commission staff's rebuttal testimony. Further, staff believes that the monetary penalty assessed by the commission is appropriate as an actual and substantial economic deterrent to the violations for which the penalty is assessed. Prairie Gas first received its license in March 2017, and since that time has been penalized for violations in 17 separate dockets, not including the current docket. 9 of those 17 dockets were for violations of K.A.R. 82.3.111. The same regulation at issue for all 27 wells in the 21-3199 docket. Moreover, the operator has had its license suspended for noncompliance with the commission's penalty orders in 10 of those 17 dockets.
I object to
Therefore,
this. It's well beyond the scope of any evidence in this case.
I believe that information is in the penalty order and is also administrative records that the commission can take notice of.
You can continue, but do try to stick to the record in these consolidated dockets.
Thank you, Chair French. Therefore, staff respectfully request the commission require Prairie Gas Operating LLC to conduct casing integrity tests at its Earl number 1, Fecht D number 1, and Watson number 1 wells, and affirm the penalty order assessed to Prairie Gas Operating in docket 21-CONS-3199-CPEN. Thank you.
Thank you. All right. One final remaining issue before we conclude today. We need to decide whether the parties need any post-hearing briefing. I don't believe we have any in the schedule at this time. Is there any request or need for legal briefing from the parties?
I would request legal briefing.
What are the issues you would like to brief?
I think the issues are the extent to which the notices of violation comport with the regulations and whether or not they are in accordance with the whether or not the staff has authority without issuance of penalties to require casing tests and to impose restrictions due to high fluid when the operator has complied with the appropriate penalty orders.
Okay. Any additional issues staff believes need to be addressed? All right, so we will allow briefing in this case. We will allow it on the two issues that have already been defined. And thank you, Mr. Thompson, for helping drill down on what perhaps the legal issue is that needs to be addressed. And the parties can address that in their briefing as well. I am looking at dates for briefing, and I think what I am going to suggest you do is simultaneous briefing and then simultaneous reply briefing. If either party wants to file an initial brief, we'll make that due Friday, January 7th. And then if either party wants to file a reply brief, we'll make that due Friday, January 21st. And I'm going to ask our pre-hearing officer, John Myers, to go ahead and, even though we're making that order right now, I'm going to have him prepare a written order to follow up and cement those dates after this hearing is concluded. John, you got that?
I do, yes.
Very good.
May I ask one clarification?
Yes,
Chairman
go ahead.
Friend, you said simultaneous briefing, and then you said if either party wants to do it. I'm assuming January 7th is the date for simultaneous initial briefs, and the 21st is the date for simultaneous responsive briefs.
That's correct. I was merely referencing that neither party would be forced to file
Okay.
either brief. If a party does not believe it needs to submit a brief, that is absolutely your choice.
I understand. I appreciate the clarification.
Very good. Are there any other issues before we conclude this hearing?
Not from
Hearing-
the operator.
Okay, very good. Mr. Marsh, anything on your end?
Don't
Commissioners?
have anything.
Very good. Well, then, at this time, we will conclude the hearing in this consolidated docket, and we are closing the record and adjourning. Thank you all for your participation in the hearing. Take care.
Thank you.